Peace, family. What's going on? It's your consumer rights guy, Jasir Ali, back at you with some more consumer rights education. And as I promised before, I'm going to be showing y'all in this video a step-by-step process on how, if you're facing a judicial mortgage foreclosure, how you can file one document, the most important document that a homeowner can file while facing a foreclosure, to stop a bank from getting a default judgment against them. Okay, so let's talk about what typically happens during a foreclosure process, right? So let's go to the beginning, right? An individual, they want to purchase a home. They purchase the home, they take out it for, a 20-year mortgage or a 30-year mortgage, and they make monthly payments on this on this house. Okay, now at the closing, before purchasing the home, they had to sign two very important documents. One document is called the promissory note. The promissory note is the instrument that a homeowner signs promising to pay back the loan from the bank in monthly installment payments. All right. And to ensure that the bank is getting paid, the homeowner then signs what's called a mortgage instrument or a mortgage document, which secures the monthly payments. Okay, and it secures the monthly payment by putting a lien against the house that the person just purchased. Okay, so what typically happens is a homeowner, they get a new house, they are excited, life is good, and then life just hit them, hit them with a curveball, and they come across a hardship. All right, and they're no longer able to make their payments on time. Okay, so when a person defaults on a mortgage payment, all right, that's considered a late payment, and the bank allows the homeowner to be late on their mortgage for at least 120 days before they start their foreclosure process. All right, and as they're going through the foreclosure process, they have a pre-foreclosure requirement that they have to execute before they can take it to the court. So in most states, they have to send you a pre-foreclosure notice, all right, where they have to let you know, pursuant to state law, that you are in the process of going through foreclosure, letting you know your options to avoid foreclosure, and to try to work something out with the bank and the attorney that's representing the bank, right? So when this happens, most homeowners, they start to get afraid, they start to worry, but they don't really take it too serious because, nothing has been filed in the courts, all right? But then when the homeowner fails to bring their mortgage payment current, that servicer of the loan, or the person who currently has the mortgage, can then go and file a foreclosure complaint, okay, against the homeowner in the court in which the house is located. All right, and when they do that, they file the complaint, and then they have the homeowner served with the complaint, either by way of a sheriff or a deputy sheriff or a process server. All right, and then a process server takes the filed complaint, and then they go and serve it on the homeowner. All right, and now the homeowner now receives this document, this foreclosure complaint that's in the courts, and then they don't know what to do. All right, they worrying, they didn't have a plan of what they would do if this was to happen. And unfortunately, when this happens, a lot of homeowners just walk away from the house. All right, they don't even realize that they have, a lot of time available to them only if they were to enforce their foreclosure rights. And just real quick, right, I had a client similar, in a similar situation. A church friend of hers introduced us, and when I met her, she was apartment shopping. All right, she was apartment shopping, and she thought she only had 2 weeks to move. All right, she thought that the foreclosure bank was going to come and they was going to put her out at the house, and her sick husband and daughter wasn't going to have nowhere to live. All right, but after talking to me and hearing the education that I provided to her, she had the confidence in our services to say, let's go forward, because she saw that it was a benefit. And next thing you know, she went from worrying about, where she was going to live to following this one document that I'm going to show you in this, or talk to you about in this video. And she ended up staying in her house for more than 2 years. All right. Not only that, she was able to pay her daughter through college while she was going through the process. So this is how powerful your foreclosure rights are. And for several years, this client didn't have to worry about where she was going to live at. She didn't worry about where her financial status was at, because she was in a more stable financial position. And she was also improving and repairing her credit, all while going through the judicial foreclosure process. All right. And this is how powerful this information is, that you can just file one piece of paper. You could put ink on paper the right way, following in the courts, and you can stop the bank from getting a default judgment. All right. So let's get back to, what you can do as a homeowner to stop the bank from getting a default judgment. All right. So the number one thing that a homeowner can do when served with a complaint is not put it down. It's not ignore it. You know what I mean? That would do nothing but make it worse. All right. Because if you don't do anything, if you don't file an answer to the complaint, the bank is going to get a default judgment against you, and then it's going to be an easier process for them to evict you out of the house in a short few months. All right. So what you want to do when you get a foreclosure complaint, you want to read the first few pages, because that's what tells you what to do. All right. Usually it comes in a form of a summons. All right. A summons pretty much describes that you've been sued, and it lets you know who sued you and how long you have to respond to the complaint. All right. So the first thing you want to do is look at your foreclosure complaint summons, or the first few pages, and see how long or how many days you have to file an answer to this complaint. All right. Now, the first thing you want to do when filing the answer to the complaint is you want to open up a blank document. All right. A Word document if you have it. And in this Word document, you're going to replicate the caption of the complaint. All right. So the caption consists of, what court you're in. Okay. It also consists of who's the plaintiff, who's the defendant in the matter. All right. In this case, if you're in foreclosure, the foreclosure bank will be the plaintiff, and the homeowner will be the defendant. Okay. And then on the other side of the plaintiff and defendant, you have the case number or the docket number. All right. And you want to replicate that caption, all right, for your answer. All right. So you want to type that up. And then when you're done with the caption, you want to go ahead and start laying out the rest of the answer to the complaint. Now, the first thing you want to do after you do the caption is you want to give an introduction. All right. You want to let the courts know who's before them, and what you're about to file. So the intro, you want to let them know that, for example, now comes John Doe, the defendant in the matter, in the above caption matter, to file an answer to the complaint. Okay. Because the number one thing a homeowner wants to do is file an answer to the complaint. That stops the bank in its tracks from quickly gaining possession of the house. So, you want to say, now comes John Doe, defendant in the above caption matter, to file an answer to plaintiff complaint, and in support thereof states the following, right? So, boom, you stop there. Now you want to look at the complaint that the plaintiff sent you, and you want to look at the numbered allegations. All right. So typically they always start out with a, plaintiff is whatever the bank name is, defendant is whoever the homeowner is. And then they describe the property that they're trying to foreclose on. And they talk about the homeowner being in default. They talk about the balance that's owed on a property as a result of the homeowner not making their monthly payments, and they ask the court for relief by asking for a judgment so that they can take the house to sheriff's sale and sell the property. Okay, so what you're going to do is you're going to respond to each allegation. All right, so it'll say, number one, the plaintiff is, blase, you know what I mean? Cricket Bank, let's just say, make up a name, Cricket Bank, National Association. If that's the party that's suing you, you can agree to that. All right. If it's not the right party, you deny it. You'll say denied or agreed or admitted, or you'll say denied, and then you'll give a reason why you're denying it. All right. The next thing you want to do is, if it's like, the defendant name is whatever the homeowner name is, you want to be logical on how you respond, because you don't want it to just seem like you just doing whatever, because that's not what this is. You're not just filing whatever just so you can file something. You want to let the court know that you know how to defend yourself in this matter, and that's exactly what we coach here at Divergent Consumer Services. We teach homeowners their arguments and how to present their arguments and how to lay it out, so that it can be properly filed. But in this case, I'm trying to give homeowners a head start, to stopping the banks from getting a default judgment, because this may be somebody's last opportunity to do so. So if you may need to file an answer tomorrow, all right, and I hope that this video can help you do that. All right, so what you want to do is, as I said, continued from before, you want to be logical in your answer. You want to make sure that if they say the defendant is the homeowner's name, and if that's your name, just you could say agreed. You don't even have to explain anything, because you agree that you are the defendant in the matter. All right, that's okay. And then if it gets down to the defendant made a default on the monthly payments, you can oppose it. You'll say denied. By way of further response, the defendant specifically denies that a default exists in this matter, or you could just say denied and just leave it at that. Or you can, there's several examples that you can use to deny an allegation. So you want to deny the allegation, the rest of them, because they're going to be talking about the mortgage payments and the interest rate and, late payment fees and all types of stuff. You want to specifically deny all those type of allegations. So for example, they may say that on, September 22nd, 2022, defendant defaulted on the mortgage and has to bring the mortgage due, and there's a remaining balance of $420,000. All right. You want to deny that, that there's a balance of $420,000 specifically that's due. And by way of further response, the plaintiff lacks standing to sue you. Something along them lines. You are filing without an attorney, so they don't expect for you to present your documentation like an attorney. However, when you're working with Divergent Consumer Services and you become a Divergent consumer, it is best practice to present yourself as a knowledgeable consumer, that's aware of their consumer rights, and you're, taking a proper stance to enforce them. That's something that we help our homeowners do by document processing things for them to take that pressure and that weight off of them. However, there are going to be some homeowners that want to do it themselves, and that's what this video was for. All right, so after you respond to all the allegations, right, you want to do what's called a wherefore. All right, at the end of the complaint, you're going to see that the plaintiff put, wherefore plaintiff respectfully requests judgment against the defendant against the house. You want to put your own wherefore in your answer, saying that wherefore defendant respectfully requests that the court enter a judgment in the favor of defendant and dismissing plaintiff complaint. Simple, right? After you do that, you want to add to the complaint, all right, it's going to put a little bit more bark in your bite. Bite in your bark. You're going to enter what's called affirmative defenses. All right, a whole different section by itself. So after you do the wherefore, you write that out. Boom. Right after that, you're going to put affirmative defenses. All right. And if you're like in the state of Pennsylvania, they call it new matter. Okay, you're going to put new matter at the top or affirmative defenses. And then what you want to do is you want to make sure you go to your state rules to see exactly what type of defenses you can add to your case, to your defense. All right, they typically have a list of limited defenses that you can raise against a plaintiff, and you want to make sure that you go to your state law and your state local rules to figure out exactly what language you need to use when it comes to applying your affirmative defenses to the complaint, to the foreclosure complaint. So after that's done, you want to, you have lack of subject matter jurisdiction as a affirmative defense. You have lack of standing as affirmative defense. You have lack of consideration as a defense. You have so many defenses to you, but you want to make sure that whatever is in your particular state, they may just have limits on what you can provide as an affirmative defense. And you'll lay them out. Another good one is failure to state a claim upon which relief can be granted. That's a good defense that homeowners can use as well. You can look this stuff up. All of this information is public record information. I'm just bringing it focused, tunnel to you, so that you can quickly be able to execute and apply, the information that I'm sharing with you. All right. So each affirmative defense, you'll put your own allegations against the bank as to why they don't have standing, as to why they failed to provide consideration, why the court lacked jurisdiction. Whatever the defenses that you're going to present in your affirmative defenses or new matter, if you're in the state of Pennsylvania, is laid out under all your affirmative defenses. All right. Next, after you get done your allegations against the bank, you want to go ahead and put your own wherefore, where now you're not requesting that the complaint be dismissed only because you filed an answer to the allegations. You're now saying that due to my affirmative defenses, wherefore defendant requests that this honorable court enter a judgment in favor of defendant, dismissing the plaintiff's complaint in its entirety. All right. And after you put your second wherefore in there, you want to then go sign it, date it. Okay. After you sign it and date it, you're going to do a separate document. All right. Because even though now you have the answer to the complaint all laid out, you're going to need to do some additional things to make sure that the paperwork can get filed and you can properly serve the plaintiff attorney with a copy of your answer. Okay, so after you do the answer to the complaint, you have to put together what's called a certificate of service. All right, with the certificate of service, all right, you're going to go ahead and replicate the same caption as you did for the answer with the court that you're in, the bank, who is the plaintiff, versus the defendant, who is the homeowner. And then you're going to put the case number or the docket number on it. And what you're going to do is, after you put that caption back together, you're now going to put in the center under the caption, you're going to put certificate of service. All right. And then under that, you're going to explain to the court in the certificate of service that you certify that that the answer that's being filed with the court that day is also being mailed to the plaintiff attorney. All right. It can either be by way of regular mail, it could be by way of certified mail only, Or in some states, you got to do it certified mail return receipt, where they have to sign for it in order for it to be served. All right. And then you get a green card back from them, and then you take it to the court and show proof of service that way when you file an answer. Okay. When you file affirmative defenses, after you do that, after you get done describing how you're going to serve the plaintiff with the complaint, you're going to want to be aware and be clear on how you have to serve them for your state. Because pursuant to the rules for Pennsylvania, you have to give the plaintiff a notice letting them know that they have 20 days to respond to your affirmative defenses or new matter. And if not, then judgment can be entered against them. So you really got to really focus in on your state rules and make sure that you're following the procedure to the fullest, so that you can make sure that your filing is being filed properly. Okay, or make sure your answer is being filed properly. Okay, so now that you have, exactly how you're going to serve the plaintiff with the answer, you're going to sign it, you're going to date it. All right, and then after that, you want to create a whole nother document, another Word document, or just continue on to the next page, and you want to copy and paste the caption on the new page or the new document. And then on that, for instance, in some states, you have to provide what's called a verification, okay, or certification. All right, you want to look at your local court rules to see exactly what is required when filing a document. For example, in Pennsylvania, there's a verification that has to be filed with, pretty much every document, pretty much saying that, you are aware of unsworn falsification or unsworn statements that are falsified to officials, and, that you're aware of a penalty of perjury and can be, penalized for it, subject to punishment. That document has to be filed pretty much for every filing that's done in a judicial mortgage foreclosure case. And, you put the verification together. Typically, they got templates on how that should be done for that court. You just need to Google or research, how to put that together for the court. But, you got the caption, you got the exact language that goes in the verification section, and then you sign and you date it. All right, and you get that document done, and then you put all three together, put those together, and you attach any exhibits that should get attached, and you make 2 copies, sometimes 3. You want to make 3 copies because 1 copy, which is the original, is going to get filed with the court and it's going to stay with the court most of the time. I do understand that some states, they give you back the original once they put it in their system. But 9 times out of 10, the original stay with the court. A copy is for you to serve the attorney, and then the other copy is for your records. Okay, that's how you want to maintain your records and keeping up with everything, is by making sure you always file a copy for yourself. Okay, and once that is done, you want to find out how to go to the court. You want to go to the prothonotary or the clerk of court that handles mortgage foreclosures. You want to go. Be aware that there may be a first-time filing fee, but if there is a first-time filing fee, you can file it by without paying. You do that by filing a fee waiver request, or what some people will consider or say informal pauperous, pretty much saying that you don't have the financial means to be able to pay for the filing, and you request that your obligation to paying filing fees are waived. Okay, so always go that route. you know, it's hard on people these days. And if the bank can see that you really have a financial hardship and that you're not in position to pay the filing fees, they will typically work with the defendant and, you know, waive the fee. So make sure you look into filling out that information to get the fee waiver granted. Okay, so you get it filed. Boom. Now you make sure you serve them. You make sure you get the file. And once that's filed on the docket, once this answer is filed, now you have completely stopped the bank from getting a default judgment against you. Okay. And what is a default judgment and how do they get it against you? They get it against a homeowner by the homeowner being served with a complaint and then don't do anything. They just don't file an answer. They just let time go by. And because the homeowner failed to file an answer, the bank was awarded a default judgment or a judgment by default of the homeowner failing to file an answer. I hope that makes sense. But it's simply the homeowner failing to file an answer allowed the bank to get a judgment against them by default. Simple. Okay, just because they failed to file an answer. So, you know, what you have done is you have prevented the bank from getting a default judgment against you and taking control of the process in which how long, you know, you have to be in your home going through the foreclosure process. Okay, because as a homeowner, you have a right to know that the party that's foreclosing on your home is the actual party that is fully responsible or capable of foreclosing. They need to make sure they have all the documentation. You need to make sure, you know, they was assigned all the documents, the promissory note and the mortgage. You have a right to ask all these things through your foreclosure rights, and by law they gotta, you know, provide that information, allow you to examine it, you know, and then, you know, build your defense off of that. So I hope that this video was very helpful. There are approximately 92,000 homeowners that are in foreclosure. I hope that this video will impact many families and allow and be allowed to be shared so that thousands of families and thousands of people's lives can be changed. All right, that was the purpose of this video. You know, how can I make change? How can I make great impact? How can I change the lives of people? So now that you have completely stopped the bank from getting a default judgment, now you are now able to have the time that you need to get yourself together. You now have the time now you have to go through the rest of the foreclosure process to ensure that you maximize the timeline of the foreclosure process. If after watching this video and you still need assistance on how to stop the bank from getting a default judgment against you, schedule a consultation with Divergent Consumer Services and we'll be glad to assist you and coach you on how to execute everything that we shared in this video and to guarantee you more time in your home, to guarantee you to build a savings, and to guarantee to improve your credit, all while going through a judicial mortgage foreclosure process.